You gonna roll down the window? Why not? Roll down the window.
Guys, can I help you?
Officer Norton, Montgomery County Constables, Precinct 5. It's obscured. Do you have your license on you?
Yes, I do.
Okay.
However, it's not obscured.
Okay, it is obscured.
You can call Officer Simpson, Sergeant Simpson, and ask him. It is not obscured.
So me not being able to see your back license plate, don't roll up your window on me.
Oh, watch me.
Okay.
You're in an accident to begin with, so don't threaten me.
I didn't threaten you. I said don't roll.
Don't roll up your window on me. It's an accident to begin with.
Okay, that's all I said was don't roll your window up on me.
The first one is the statute that I wanted to look at is that bicycles and motorcycle racks attached to a vehicle in normal or customary manner cannot be used as a basis for obstructing a license plate. It's actually spelled out in the statute. That's problem number one.
All right, y'all. We're on the Audit channel, and this is titled "Fearless Grandma Stands Up to Corrupt Cops and Wins."
Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers interfering, pat-downs, and the First Amendment, and is brought to us by Duck the Police's channel and Lackluster's channel. Be sure to check out the description below and give them the credit that they deserve. This will be another double feature episode, so be sure to stick around for our coverage of both of today's interactions. On September 9th, 2024, a deputy with the Montgomery County Precinct 5 Constable's Office in Texas initiated a traffic stop on a driver who pulled into a gas station parking lot. The interaction that followed was captured on the deputy's body camera.
You gonna roll down the window? Why not? Roll down the window.
Guys, can I help you?
Officer Norton, Montgomery County Constables, Precinct 5.
You already know whenever they approach you and they start off speaking like that, you already know it's gonna be a difficult time. Anytime they approach and they come off like this, you already know it's gonna be bad.
The reason I pulled you over is your license plate is obscured. I cannot see your license plate.
You're full of crap anyway because it's got my bicycle things on it.
It still can't be covered.
Yes, it's not covered. It is, but
It's obscured.
legal.
No, it's not. I cannot see your license plate. I cannot see your license plate.
I'm sorry.
Okay, so it's obscured. Do you have your license on you?
Yes, I do.
Okay.
However, it's not obscured.
Okay, it is obscured.
You can call Officer Simpson, Sergeant Simpson, and ask him. It is not obscured.
So me not being able to see your back license plate, don't roll up your window on me.
Oh, watch me.
Okay.
You're in an accident to begin with, so don't threaten me.
I didn't threaten you. I said don't roll.
Don't roll up your window on me. It's an accident to begin with.
Okay, that's all I said was don't roll your window up on me. Where's your license?
It's obscured.
Okay.
That's correct.
You can read it.
We can agree to disagree.
The deputy claims that the driver's license plate is illegally obscured by the bicycle rack, and the driver argues that it is not. Subsection A7 of Section 504.945 of the Texas Transportation Code states that, quote, a person commits an offense if the person attaches to or displays on a motor vehicle a license plate that has a coating, covering, protective substance, or other material that distorts angular visibility or detectability, alters or obscures one half or more of the name of the state in which the vehicle is registered, or alters, covers, or obscures the letters or numbers of the license plate number or the color of the plate. Now, while this could conceivably prohibit covering the letters or numbers of the license plate with a bicycle rack, the statute specifically states that, quote, subsection A7 may not be construed to apply to a bicycle or motorcycle rack that is...
You can't change it and say that it's for something else when you see that it's for bikes and she has bikes, and it's not like she couldn't see it. It's because you couldn't see it. You had to get closer to look.
is attached to a vehicle in a normal or customary manner. Accordingly, it is highly probable that a court would conclude that the driver's license plate was not unlawfully obscured, and that therefore the traffic stop was unlawful from its initiation.
Where are you coming from today?
None of your business.
Okay, cool.
Right.
Any weapons in the vehicle?
None of your business.
It is my business, actually.
No, I don't have to answer any more questions.
Yeah, you do. Are there any weapons in the vehicle?
Here you go.
Are there any weapons in the vehicle?
No.
Okay. Any illegal narcotics?
I'm not answering any more questions.
Okay, cool. Go ahead and hop out of the vehicle for me.
Excuse me?
Hop out of the vehicle.
The fact that she answering your questions the way that she want this lady to tell her everything about her, but where you going? Where you like? It's crazy. Y'all see, this is an insane situation.
Excuse me?
Go ahead and hop out of the vehicle.
Say that again?
Go ahead and hop out of the vehicle.
No.
Get out of the
I'm not
vehicle.
getting out of the vehicle.
Yeah, you are.
Oh, no, I am not.
Yes, you are.
No, I'm not.
Yes, you are.
No, I'm not.
8520. Can you send me another unit? I have a occupant that's refusing to get out of the vehicle.
I'm not getting out.
Yes, you are.
Can I get a second to 850? All unit 2 via channel sport cover close, channel sport cover close.
I do not have to answer any questions, and I am not getting out.
It's a lawful order.
No, it's not a lawful order.
Yes, it is. It is a lawful order. Me telling you to get out of the vehicle.
I am not getting out.
You can open up the channel. You can get out of the vehicle, or you can go for. We'll sit here and all day. All I asked was for you to get out of the vehicle.
I am not getting out of my vehicle.
I don't know what's in this vehicle. You're not telling me if they're weapons. I asked you if they're weapons. You said I don't have to tell you.
There's no weapons in my vehicle.
You said I don't have to tell you.
There's no weapons in my vehicle.
Okay, cool. Well,
So I do not have to get out of my vehicle.
yeah, you do. It's a lawful order.
No, it's not.
Okay, we can agree to disagree.
I'm not doing anything wrong. There is no reason for me to get out of my vehicle, and I gave you my driver's license.
Okay, well, we can either pull you out.
Call Sergeant Simpson.
I don't need to call Sergeant Simpson.
There is no reason for me to get out of my vehicle. I've not done anything wrong.
So me asking you is a lawful order.
No, it is not.
Yes, it is.
It is not.
It definitely is a lawful order.
My vehicle.
Okay.
It's not a lawful order because there is no reason for it.
Okay, she already locked it.
The deputy threatens to take the driver to jail for interfering, for refusing to get out of his vehicle, arguing that it is a lawful order. As we have discussed many times in ATA, the Supreme Court held in the 1977 case of Pennsylvania versus Mims that a police officer may order the driver of a lawfully stopped car to exit their vehicle as a matter of course. Likewise, courts have held that Texas drivers who refuse a lawful order to exit a vehicle may be arrested for interference with public duties in violation of Section 38.15 of the Texas Penal Code, which states that, quote, a person commits an offense if the person with criminal negligence interrupts, disrupts, impedes, or otherwise interferes with a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law. In the 2024 case of Castro versus Corey, the Fifth Circuit Court of Appeals, which has jurisdiction over Texas, held that a driver's, now quoting, repeated refusals to exit his vehicle interfered with a peace officer's duty in violation of Texas Penal Code Section 38.15. However, in reaching this conclusion, the court specifically noted that the district court had determined that the officers involved had reasonable suspicion for the initial stop and seizure of the driver, which, according to the Fifth Circuit, now quoting, confirms that the officers were exercising lawful duty as required by this statute. Additionally, the Fifth Circuit held in the 2007 case of Freeman versus Gore that an individual could not be arrested for a potential violation of the Texas interfering statute for disrupting an unlawful warrantless search of her home. The court concluded that a reasonable officer would have known that they could not lawfully search the home, and that, therefore, the homeowner was not, now quoting, interfering with the exercise of any authority granted to the deputies by law. Consequently, because the traffic stop itself was not lawful, the deputy could not lawfully order the driver out of the vehicle under the Mims case, and a court would therefore likely find that the driver could not lawfully be arrested for interfering, for refusing to exit the vehicle.
That's all right. We got a sergeant on the line right now. You can sit here, or you can comply with our orders.
There is no vehicle. There is no reason for me to get out of my vehicle.
I don't know what's in this vehicle. You were hesitant on me asking if.
Let me stop this right now. Just so y'all know, if y'all don't already know, this officer is completely wrong in this situation. It's the way she's going about everything. You wouldn't expect this, and you wonder why are they hiring people like this, and what training are these people going through to where they feel like they're doing the right thing here.
If there were any weapons in the vehicle and you said no, I don't have to tell you. So
No weapons in my vehicle. If you're not shining your flashlight in my eyes, I'm deaf.
You're deaf?
well, that has nothing to do with a flashlight in your eyes. Anyways, I'm gonna run her.
Basically, it's like
It's a very common thing across the country as well. It's not even just our community here.
So, as y'all see, she obviously has bikes and she has a bike rack. And the cops is saying, oh, I can't see your license plate. And it's obscured. When it's very legal for you to have a bike rack and the bike's covering the bike. So unless she goes all the way up to the car, y'all already know this is absolutely ridiculous. What she's trying to make this lady go through for no reason.
Hands on the hood. Anything y'all need that's gonna poke prod me? Pat you down for officer safety.
No.
Hands on the hood.
That's not a pat down. That is pull my bra.
It is definitely a pat down. We can argue all you want. I don't know why you are being so defensive.
You are not patting me down. You are feeling up under my bra.
Is that I'm allowed to?
The deputy claims that she is allowed to feel under the driver's bra as part of the pat-down, and the driver protests. During a Terry or traffic stop, law enforcement officers are generally allowed to perform a limited pat-down search of a person for weapons if they have reasonable suspicion that the person may be armed and dangerous. As the Supreme
So by that, how the way that's worded, they're gonna use that, whenever they feel like they want to use that. But we know that she wasn't checking her for weapons, and by you pulling up the back of her bra, there's no reason for you to do that to check for a weapon. If she had a weapon, you would know by patting her back. But or y'all know this is
Court explained in the 1993 case of Minnesota versus Dickerson, quote, "The purpose of this limited search is not to discover evidence of crime, but to allow the officer to pursue his investigation without fear of violence. A protective search must be strictly limited to that which is necessary for the discovery of weapons which might be used to harm the officer or others nearby. If the protective search beyond what is necessary to determine if the suspect is armed, it is no longer valid under Terry, and its fruits will be suppressed. Accordingly, even assuming that the officer had reasonable suspicion for the initial traffic stop, which she did not, and that he had a reasonable belief the driver was armed, which is questionable, a court would likely conclude that the scope of the pat-down exceeded the permissible scope of a Terry stop and frisk. While an officer conducting a lawful pat-down may pat the exterior of clothing near the bra, a court would likely find that the deputy's decision to feel under the bra in this case was more invasive than permitted by Terry, as the level of intrusion appeared to be aimed more at discovering evidence of a crime rather than searching for weapons, especially since the deputy had no specific.
Okay. Anything in the car that you're not supposed to have? Okay. Do you mind if I search the vehicle?
Yes, I do.
Okay. Okay. Stay right there.
And like this woman is the one causing her problems when it's insane.
Can you make note that the occupant got out of the vehicle? And do we have any canine narcotics available? Huh? Yeah.
Now She gonna call.
Yeah, I'm gonna wonder if it's enough for me to. Technically, she was interfering.
Oh yeah, I'm done it.
I'm gonna call the DA. Did you call the DA before you? Yeah.
So she about to call the DA, and the DA is gonna tell her that what you're doing is all bad. But the DA wasn't firm in telling her that she was wrong. The DA was just basically saying, yeah, we're wrong, you're wrong, but if you feel like doing it, go ahead and do it anyway. That's pretty much what he told her.
What my guy had physically had to remove him out of the car.
All right, I'm gonna call the DA. Hello, it's Officer Norton with Montgomery County Constable's Precinct 5. I got a question for you. So out on a traffic stop for obscured license plate. She has like bikes covering her license plate. I can't see the license plate. When I told her that I wasn't able to see the rear license plate, she argued with me and says that it's not obscured. I asked her multiple times to get out of the vehicle because when I asked her, sorry, hold on. When I asked if there were any weapons in the vehicle, she said that she didn't have to tell me. And finally, after asking her multiple times, she said, no, there's no weapons in the vehicle. I then asked her, okay, well, do you mind stepping out? That way I know, you know, for my safety, your safety, everything's okay. And then she refused to get out of the vehicle when I asked her multiple times. It took 4 other officers to ask her verbally. We didn't have to physically remove her. As I'm
So she didn't want to get out because really you pulled her over. You pulled her over for nothing and didn't have any basis about the whole stop. But anytime they ask you to get out the car, the best thing to do is just get out the car.
patting her down.
But it doesn't mean they're right about telling you that.
Seeing if she like, you know, stuffed anything anywhere in her bra. She said that I was not doing a pat down, that I was illegally searching her. So I was going to see if that's enough for interference.
Give me a second. I'm going to look at something.
Okay.
Okay.
Here's where you're at.
I'm with you. Technically, yes, you have the violation if you want to file it. How?
Yes, if you want to file it. What type of DA is telling an officer on a traffic stop?
Bad. The first one is the statute that I wanted to look at is that bicycles and motorcycle racks attached to a vehicle in normal and customary manner cannot be used as a basis for obstructing a license plate. It's actually spelled out in the statute. Now, that's problem number one. Problem number two, she has a valid point about the search in saying that you patting her bra is not a pat down, it's a search. So the long and the short of it is, I would not do it, but if y'all really want to bite off that fight, yes, we'll file it.
No, I mean, I'm going to go with obviously what you say, because I'm calling you to get your opinion on it. I was under the impression that if we weren't able to see a plate in the back at all, then it was obscured.
Well, I read you the exact language, and so you can see how you think it applies to your exact facts, because you're looking at your situation live. I'm not.
Yeah, no, I got you. Yeah, I mean, I physically can't see the plate, so like I legit had to go under the bikes as I'm pulling over the vehicle to see the plate. So
I'm giving you my distance, so yeah, whichever way you want to go, it's fine with me.
Okay. All right. Thank you so much.
Yeah.
All right. Bye.
We didn't get a response.
You know, it's wild that a DA would tell an officer, just do whatever you want, pretty much. It doesn't matter. Well, I'm telling you that you're wrong about it, and you're gonna have problems when it comes to defending yourself in court. But if you want to do it, go ahead and do it. What type of DA is telling this to officers? And you see all the problems that we have to deal with. Just this whole thing is just, y'all see, like,
to any other shift.
That's there. You can disregard.
Were you wanting to speak with the sergeant, or?
You have any questions? All right. Well, the sergeant's right here if you want to speak to him. If not, you're more than welcome to go on about your day.
Thank you.
Do you have any questions for me, for him? No?
You're welcome to go ahead about your day like you was doing before I pulled you over and wasted your time and stressed you out. All of this stuff. But basically, I'm saying, okay, you can go ahead and do what you're doing anyway. What type of...
No? Okay.
After talking to the DA, the deputy allowed the driver to leave without further incident. Very little information is available about this encounter, and it's unknown if the driver filed a complaint or intends to pursue legal action. Overall, the deputy gets an F for maintaining a rude and unprofessional demeanor throughout the encounter, demonstrating a fundamental misunderstanding of both Texas traffic laws and the Constitution, and repeatedly violating the driver's Fourth Amendment rights. While the Supreme Court has upheld the constitutionality of traffic stops based on so-called reasonable mistakes of law, in this instance, the statute explicitly stated that it did not apply to bike racks, showing that the deputy was simply ignorant of the provisions of the statute that she was attempting to enforce. When the driver attempted to correct her understanding of the law, the deputy responded in a condescending and defiant manner, despite repeatedly being incorrect in her assertions. And while the deputy at least did not attempt to pursue interfering charges against the driver, she also did not apologize for or even appear remotely remorseful about unlawfully detaining her, searching her, and threatening her with arrest. This encounter underscores the critical importance of officers thoroughly understanding the laws they enforce, and highlights how a single misinterpretation of a statute can escalate into multiple constitutional violations. The driver gets an A for demonstrating a strong understanding of her legal rights, vigorously advocating for herself throughout the encounter, and attempting to educate an unknowledgeable deputy. That being said, I do want to generally caution against refusing officer orders to exit vehicles, as the Supreme Court has granted significant discretionary authority.
Oh, so yeah. If they tell you to get out the car, it's the best thing to do is get out the car at that point. But that doesn't mean give up your Fourth Amendment
authority to officers to order drivers and passengers alike out of vehicles during lawful traffic stops. It is important to remember that a driver does not have to have committed an offense for a traffic stop to be lawful. Rather, the stop must be supported by at least reasonable suspicion. As we discussed earlier, reasonable suspicion can be based on a reasonable mistake of the law, as well as a reasonable mistake of fact. Or it could simply be that the driver's vehicle matched the description of a vehicle involved in a crime. Additionally, in determining whether a traffic stop is lawful, courts look at whether there was reasonable suspicion or probable cause for any offense, not just the offense that the officer actually believed was committed. In this case, the traffic stop seemed to be unconstitutional, but it is possible that a court could conclude that it was lawful based on information not available to us. As such, I suggest that citizens always comply with orders to exit vehicles, even when they appear to be unlawful.